Right. Good morning, everybody. Well, actually, it's probably afternoon now. Firstly, I'd like to thank the IUA again for facilitating this seminar, and also, of course, to Deborah Finch, who does an awful lot of organisation for us. For those of you that don't know Judy Holden, she's sitting at the back, she's not feeling that well. That's our new secretary, or not so new anymore. Please have a word with her afterwards. So, at a distance, yeah. I'm delighted to be chairing this seminar on general average in the offshore industry. Most of us here and joining remotely are no doubt well versed in GA when it comes to maritime adventures, and our speakers today will enlighten us on how it also applies in the offshore industry. Both our speakers are eminently qualified to speak on this topic, and so without further ado, I will briefly introduce them before we start. Michiel Starmans is a fellow and past chairman of the Association of Average Adjusters, having initially worked as an average adjuster with Richard Togg Lindley before joining the Splitoff Group in Amsterdam over 22 years ago as director in the legal department, where he deals with P&I and hull and machinery claims. Michiel is also a member of the BIMCO documentary committee on behalf of the Dutch delegation. Inge Johannessen is an associate member of the Association of the AAA and has passed the Norwegian average adjuster exams. Alf spent 25 years at Gard, previously Vesta, and is now senior claims manager at DOF, a company that offers offshore and subsea services with a fleet of support vessels. So over to you, Michiel.
No, the door is closed. Okay. Good morning or good afternoon. Well, it's very good to see so many people of you here. So I'm sure the sandwiches must be excellent. So there's a good reason to come over, and hopefully we also can enlighten you on this subject. So when did this all happen? It happened about a year ago when this matter was discussed within the BIMCO, when we had spotted that there was a possible problem with the general average clause that did not appear anymore in some of the newer charters. So we discussed that. Burkhardt was the chairman then. He had a word with Alf, because we actually issued an advisory note via LinkedIn also in June, where this was explained that there might be some problems. And there's been an advisory note from the BIMCO also, where they advise you what you need to do or be aware of. So you cannot just leave it as it is. Something needs to be done. I'm not sure if that advisory note really comes in with a lot of the parties that are actually contracting. So that's why I welcomed very much the idea to give this seminar together with Alf, so we can enlighten the people once again. Certainly also the ship owners need to know this. So this is also a role that the broker can have, and the adjusters can have, and the P&I clubs can have. So they can really, hopefully, find a solution that parties do take action if needs be, or whether they still decide to exclude general average, but can it then be covered under any of the insurers? So that's what we're going to talk about here. I'm going to talk a little bit about the general average. Is only one slide, because I expect that everybody knows general average who's here or watching us. So that's a very short item. Then I will also look at the BIMCO contracts that are being used in this industry, certainly for our group then. And then Alf will, after my session, he will talk about the cover that exists under the hull and machinery clauses, also under the well care clauses, which are actually the clauses that deal with the whole contract, the project that's being built. And then we come to a conclusion together. Then we have the questions, so let's start. Any questions are for afterwards, we've decided. So, right. That's us. Yes, what do we have here? We are Splitoff, the Splitoff group. We have about 140 vessels now. And we ship this kind of cargoes, offshore equipment, etc. We ship that around the world. And of course, about 20% of the vessels are being used in the offshore industry. So when I look at it from what is this, I see here a deck cargo of windmill blades. For me, there's not much difference between carrying this kind of cargo or carrying other deck cargo. So for me, it's just like a general cargo. So is there a reason to treat it differently? I think we all agree here that what you see, that there is more than one property at stake. This is a conclusion that you can draw. So keep that in mind to see where we're going. Here we have an image of one of our new vessels. It was being built, so this is just a drawing artist draw up. And you can see here that we are carrying and installing transition pieces on monopiles. So this is actually a way of building up a windmill. So this is in 3 sections. So somebody put a monopile in there before, and we are being contracted under that contract to carry the transition pieces from a storage yard to the offshore location. There are more than one property at stake here, I would also say. So a collision could happen on the way when you go there with your cargo. Here we have another of our vessels. It's one of the big lift vessels, part of the same group. They are supplying jackets to the installation vessel of Van Oort. So they are going from a storage yard to the vessel, or to the vessel of Van Oort, to help them to install these jackets on the seabed. So let's then look at the one slide that I have, 2 slides I actually have, on the general average. So what we have is that in all the maritime countries, we usually have a reference to general average. It's in most shipping nations it's like that, and under English law there's also a reference to a statute. It's called the Marine Insurance Act, and in the Marine Insurance Act we find reference to what is a general average loss and how we should deal with it. So we have here section 66, where it says that the general average loss is a direct consequence on the General Average Act, and it includes expenditure and sacrifice. Expenditure is, for example, if you order a tug to assist a vessel that's aground, that's an expenditure. And a sacrifice is something that gets damaged. So a jettison of cargo, that's gone, that's a loss. I underlined some of the other items, because normally when you discuss a general average situation, you go on like, yeah, reasonably, intentionally, but I here pointed out certainly the property imperiled in the common adventure. Lots of people always think, general average is all about cargo. But we can see that in this industry, we're not only dealing with cargo, but we're also dealing with equipment, charter's equipment. It does not exclude that this only applies to cargo. It applies to all property that is imperiled in the common adventure. Then the third section is also interesting. The party on whom it falls is entitled to a rateable contribution from the other parties. So what falls on a party? What is that, to fall on? I haven't found that actually, so this is just my mind speaking. I would normally think that a sacrifice is quite clear. That is, you lose the property, that's gone, that's the loss. But this is the part that I would like to point out here, is when you talk about general average expenditure, that is one of the parties who's advancing the general average expenditure. So if you have a tug, so who's going to order the tug to come and assist ship and cargo? The ship owner might do that in most cases. So he's advancing the tug charges and expects to get a rateable contribution from cargo or equipment. We have similar rules under the York-Antwerp rules, that's similar wording. The only difference that you can see is that they refer to a common maritime adventure, and when we go back to general average, they talk about a common adventure. So what is that then? A common maritime adventure. A maritime adventure involves a common adventure exposed to sea risks. So that's why we do not see this, of course, on land. It's not like when you have a truck with a flat tire that you declare general average to replace the tire. That doesn't happen. So it's very important that it's exposed to sea risks. I cannot see anywhere that maritime adventures should be limited to maritime voyages from A to B. And this is what we're looking at today. We are not going to go from one port to the other. We're going from one port to an offshore site. That can also be a maritime voyage. We can have, for example, some laden tankers that are anchored at a storage ship. So they're loading oil in one place. They're waiting for the price to go up. They can be at anchor for half a year, and then they deliver it to somebody. So it's a long voyage, but it's still a voyage. Offshore diving support vessels, that's what you're going to talk about afterwards, so I won't talk a little bit too much about that, but that will be explained later as well. So let's just now go to the type of charters that we work with the Spreedoff Group. So we have the Heavicon 2007 charter. That's a voyage charter. The reference I take there is basically the reference as is being advised by the BIMCO on their website. So it's the Heavicon Voyage Charter Party. It's a standard transportation contract for the super heavy and voluminous cargo. Sorry, I can't pronounce that word well. It's a knock-for-knock contract where cargoes are almost exclusively carried on deck. It exists in 2007. It has a general average clause in there, which says that general average shall be adjusted and settled in London according to the York Antwerp Rules 1994. Then it has a knock-for-knock system. A knock-for-knock clause means basically that every party bears his own losses, damages and personal injuries, irrespective of the cause. So you don't look at the other party. It's actually an ideal world, you would think, knock-for-knock. I've got my ship insured, you got your cargo insured. Whatever happens during the trip, any damage to the ship, you deal with your insurance, any damage to the cargo. It's like that. If you have general average, there's a contribution that you're going to ask. So that's why general average should be excluded under the knock-for-knock clause. That's what happens here in the Heavicon 2007. You see that there's an exclusion for general average. That's important because the knock-for-knock clause actually states, notwithstanding anything else in the contract, then it should say accepting general average, accepting dangerous cargo, that is also one of the exclusions, pollution, unsuitable bunkers. When the charterer, this is a voyage charter, but okay, this is basically what it says. So basically, if you don't put it under as an exception under the knock-for-knock clause, it says notwithstanding anything else in the contract. Basically, it overrules all the other bits. So it's important that that exception appears in the knock-for-knock. Otherwise, it overrules a general average clause in the same contract. Another voyage charter, which is often used in this industry, is the Heavy Lift Voyage Charter, 2009. This is for the smaller heavy lift cargoes, the mid-sized heavy lift sector carrying specialist cargo. Unlike the Heavicon, it operates on the basis of the ordinary cargo liability regime, which is the Hague-Visby rules, and it carries cargo on the deck and on deck, mainly. Also, this charter party has the same general average clause as the Heavicon charter party. It doesn't have a knock-for-knock clause, as I say. It's a Hague-Visby rules regime. Let's see what the time charters exist in this business. Supply time is one of the most common charter parties that exist here. And the first one is actually next year, is 50 years ago. So 1975, there was the first supply time charter party that was needed with the upcoming of the offshore industry. I Until 2005, these time charter parties, they were based on the same regime. They had a reference to a general average clause, and they also have a knock-for-knock clause, which accepted general average in there. Now, what do they describe on the WIMCO website about this clause? It's a time charter party for the offshore support vessels, which operates on a knock-for-knock liability regime. It also provides for loading and transporting cargo and/or property and/or any other service for the charterers during the time charter period. So initially it was thought of that supply time would only be like small supply vessels going to an offshore site and not being involved with any transportation of cargoes, but it has become very popular. This supply time is being used even in the tuck and tow business. They come with supply times, so it's a very common contract. And I think that it wasn't realized that a lot of cargo was being transported as well. The first slide which you could see with the windmill parts, that could have well been under a supply time charter. Yeah, so we had a case where one of our vessels touched the ground and got damaged. It was not in a very nice location, it was in Antarctica, and she was on the way back to Tasmania. She sustained damage and she had to sail to the port of refuge, which was the closest by, which was Perth. That's where she carried out some temporary repairs before she could proceed to destination. So when I got the charter party, I was looking at it and I kept on going and say, well, hey, now try again, try again. I was looking for the general average clause. I had not realized that there was no general average clause anymore in this case. So then you start to realize, hang on a minute, this is really spectacular, because is this a mistake or not? Then we found out that, as you already said, I'm also working in the WIMCO documentary committee, so I asked there, how did this come about? What was the reason behind it? The reason was basically when they started up with wind time in 2013, they decided, okay, let's skip all the cargo related clauses from this charter party. So it's really made for this purpose. And that's how they actually decided to delete the whole GA clause. They thought that it was not necessary in this business anymore. Now we are being faced here with a situation where you have a general average. What happens then? There is no reference to a general average clause. Does general average still exist? Well, let's see. Wind time is another one. So this is the one I refer to. So this was the first charter party from WIMCO where they decided to delete the general average clause. And you can see that it's also for the time chartering, for the transfer of wind farm personnel and equipment. Equipment is a property. It also states in the charter party, if you read it, that charters can also use the vessel to carry lawful cargo, whether on or on the deck, and that the crew will assist in loading, unloading cargoes alongside offshore units. So you can see when they drew up this charter party that they made provision for it, that it would also be used for cargo purposes. This is what it states. This is not what I invented. That is in the wind time charter party. So why do you exclude general average then? This is the third time charter which they use, which is for accommodation support vessels, where crew is being placed and the vessels are used to transport crew and also equipment. It's also referred to in that same charter. Equipment is property. Once again, no general average clause and no exception in the knock-for-knock clause. Right, this is the WIMCO advisory note. So go back to my case. No general average clause. Went back to WIMCO, say, well, what do we need to do then? Let's assume that that vessel went aground and you would have to employ a tug, and the tug would cost you $1 million. Who would have to pay for that tug then, if there's no general average clause? Without a general average clause, it basically means that you need to adjust a general average on the basis of the law in the country of destination. Now, the country of destination was Tasmania. I asked one of our lawyers whether there's any reference to general average in the Tasmanian law, which is based on Australian law, and there is some reference, but the York and the rules are not incorporated there. So you just have to base it on Australian law then, if you do a general average. So this is then the advisory note that was issued by the BIMCO. They realized there's something wrong possibly, because if you just delete the general average clause, does that also mean that you delete general average? And after some advice from other lawyers as well who were there, that was found that no, this is not sufficient enough to delete the idea of general average. General average just exists because it appears in maritime nations law. It's incorporated in there, general average. It exists already for 4,000 years. So by not mentioning it in a contract, that doesn't mean that you abandon general average. So the advice from the BIMCO advisory note was that we need to decide whether to exclude or include general average and the new Jason clauses in the charter party. If a vessel is carrying cargo, property, and or equipment belonging to charterers or members of the charters group. The absence of a GA clause in a contract does not mean that GA principles may not be relied upon by one of the parties involved in a casualty as a basis for making a claim in respect of their GA expenditure and or losses. However, any such claim is likely to be made more complex and contentious in the absence of a GA clause in the charter party, which specifies who must adjust the GA allowances and according to which York and rules. That's what the GA clause does. So it creates a lot of insecurity then. It goes on further than it. If parties elect to include general average in the wind time, supply time, or ESFA time contracts of carriage, then they should include the BIMCO general average clause, which states that GA shall be adjusted, stated and settled in London according to the York and Rules 2016. So that's going to be, you can also use another one. You can also say, okay, I use the supply time 2005 clause. It's not necessary that you refer to 2016. You could also have the old one, which refers to 1994. On top of that, BIMCO advises now to all the parties that are going to use one of these contracts that if you include a general average clause, you should also add an exception in the knock-for-knock paragraph of the liabilities and indemnities clause. This is what I already explained before with the notwithstanding part. So a general average clause itself, without accepting it in the knock-for-knock clause, will actually still override the knock-for-knock clause, prevails over the general average clause. So that's why the exception is very important in the knock-for-knock clause. If parties decide we want to exclude general average, then they drafted a clause which you then should use in your charter party, which says, it has been expressly agreed between the parties that claims on the basis of GA shall not be made by or between the parties to this charter party, including those listed in the charters and owners group or their insurers. Any sacrifices or expenditure of a GA nature shall be treated as falling under the provisions of the knock-for-knock clause. So that ends it. However, GA still exists, as I said. This is just a provision that you say, okay, fine, the GA, whatever you have incurred, falls on you. You cannot recover it from any of the other parties. So what they then advise also, parties should contact their insurers to seek advice on the implications of their insurances of expressly excluding the right to claim contributions to general average sacrifices expenditure including to ascertain whether any additional cover is needed. So go to your insurers. Referring to my case, what I have, for example, in our hull policy, we have a general average absorption clause. But what that clause only says is that the general average is being paid for by the hull and machinery up to a certain sum. But that still refers, of course, to the general average as has been agreed in the charter party. So this was quite interesting, of course, to see what we would deal, how we would deal with this case. There is no GA clause in the charter party. That's why we decided now, upon renewal, that we will put in the hull policy, if there is no reference to any general average in the contract of carriage, or the time charter or voyage charter, the general average will be adjusted on the basis of the York-Gatter rules. Fill it in. You see, so then that's clear that the adjuster will still need to make an adjustment. Why does he need to make an adjustment, still the adjuster? Is there still business? You will explain it later. General average and particular average are very interesting. Okay, P&I cover. There is a provision under the P&I Club rules which says that they will pick up the cargo contribution to general average in case the cargo interest can prove that there was a breach of contract by the owner. Now it is clear, if you exclude GA specifically, there's no breach of contract. You actually comply with the contract. So the idea is, what I raised with some of the P&I people, I say, well, you need to have a think about it, whether this rule needs to be amended to also include any GA contribution from cargo, which you cannot claim because you've excluded it, but it's still there, that you can claim that from the P&I. So this is interesting. This question has been put forward, I understand, with the Production, Operations and Specialist Craft Committee of the International Group of P&I Club, and is currently under consideration. I know there's some P&I people here in the room, and yeah, we look forward to hear what comes out of that. But that was apparently put forward in October. So what is relevant here is, if parties decide to exclude GA, as I explained, the ship owner would like to get covered for that. So if the tug which you employ, if there is this tug and it costs $1 million, you can imagine if you have excluded general average specifically between the parties, ship is worth 20 million, cargo is worth 100 million on the same ship. Who would order the tug in an emergency situation? Could you as a ship owner then go to cargo and say to charters, can you please order that tug? Or will the ship owner have to order that tug? And what's happening then to cargo's contribution? He won't be entitled to cargo contribution. So that's going to be an interesting item as well. And that stops my presentation just in time. So Elf, take over, please.
Yep. Thank you. Good afternoon, everyone. Let's start with showing a little bit about the vessels my company is running. I've been working for DOF now for 10.5 months after 25 years with the Guard's Hull Machinery department. So I'm not yet, will say I'm a specialist on this particular area, but I've been generally working on claims for many years. So I think I have something to contribute with. We have now a fleet of 77 vessels, owned mostly, but also managed and chartered. We have ROVs, remotely operated vehicles, and AUVs, autonomous underwater vehicles, on board this vessel. What you see here is an anchor handler, which is, among other things, used to move things around. Could be an oil rig, could be a floating windmill, as we see in the background here. So, yeah, could be more than one interested in an adventure. We have the traditional platform supply vessel. which is carrying cargo to offshore installations. Again, perhaps mostly smaller cargo, but several interests on board. And we have kind of this beauty, subsea construction and pipelaying vessel. This vessel will have 2 ROVs on board. It also has some big carousels with some product on it. Could be pipe, flexible pipe, could be a cable which is supposed to be installed on the seabed, and also could be some other equipment for subsea construction on board, which is often mobilized at one place, and then the vessel would go to where the construction is going on and place it on the seabed there. So just a small reminder again as to GA, as I know that most of those taking part here is well acquainted with GA, but some are perhaps not that acquainted with it. As I see it, GA is basically a very simple cost-sharing agreement where all parties involved in the common maritime adventure contributes to indemnify the person incurring costs or sacrificing their property to save the other property involved in the adventure from common peril. And this is the original common safety principle, the original GA principle dating back some 3,000 years or something. And then you also have the common benefit principle, typically port of refuge expenses for what is said in the Johannessen for the safe prosecution of the voyage. And we will see for these vessels, the voyage can sometimes be a little problematic to define, but we will revert to that. And again, such costs are apportioned between the parties involved based on the values at termination of the adventure. So on a vessel like we have here, what would be the contributing interest in case of a GA situation? Well, you could have the ship itself, of course, the value of the ship, the value of the bunkers on board. You can have some equipment loaded on deck. You can have the product on the carousel, which can be of substantial value. You can have ROVs on board. And you can have other subsea equipment which have a value on board, which could be owned by the ship owner, could be owned by any other party, and also could be separately insured from the vessel and so on. So one might consider, as Michiel mentioned, the possibility of contracting out of GA. And what would be currently the effect on insurance if you do so? Well, what you will achieve is uncertainty as to how GA sacrifice sustained and GA expenditure incurred by one party can be recovered from their insurers, as no GA contributions can be claimed from other party on a knock-for-knock regime, GA excluded. So you cannot automatically go to an insurer and have cover. Standard insurances normally cover only the share of GA allocated to that insured property, with the exception, again, as Michiel also mentioned, with the GA absorption clause in the policy, where you can claim GA in full from hull insurers up to an amount stated in the policy. And also, as Michiel mentioned, there's currently no P&I cover for any shortfall here, unless it's resulting from a breach of contract. So which insurances could potentially respond to these contributions in GA? Well, there's hull machinery for the ship. There could be cargo insurances for some of the equipment on board. You have the construction all risk or car insurance, which will embrace everything needed for a specific construction project, a subsea construction project. And you can have subsea equipment insurances, as it's called. It's normally for ROVs, AUVs, and so on. Potentially other. We'll be looking now at various, these insurances could be subject to different sets of laws and jurisdictions, and I will look a little bit into policies based on English law and policies based on Nordic plan and Norwegian law. So, English law policies, then you have the Marine Insurance Act, where section 64.1 says that a particular average loss is a partial loss of the subject matter insured caused by a peril insured against, and which is not a general average loss. So if it's general average, it's not particular average. Then you have in section 66.4, subject to any express provision in the policy, where the assured has incurred a general average expenditure, he may recover from the insurer in respect of the proportion of loss which falls upon him, and in case of a general average sacrifice, he may recover from the insurer in respect of the whole loss without having enforced his right of contribution from the other parties liable to contribute. So what does this mean? Well, the starting point, what is general average, cannot be claimed as particular average. For sacrificial loss in general average or loss or damage to subject matter insured, you may claim in full from the insurers without enforcing right of contribution towards other parties. However, one should note that there is a general right of subrogation to the insurance that may also apply to the contributions in GA under English law, as I understand it. For general average expenditure, only the proportion falling on the subject matter insured can be recovered, again with the exception of the GA absorption clause. And the standard wordings for each kind of insurance seems to reflect this. You have in ITC Hulls 11083. This insurance covers the vessel's proportion of salvage charges and/or general average, reduced in respect of any underinsurance, but in case of general average sacrifice of the vessel, the assured may recover in respect of the whole loss without first enforcing the right of contribution from other parties. And I think the word first here confirms what I said, but there is a right of subrogation for the insurers towards the GA contributions from other parties. Then you have the cargo clause down here. This insurance covered general average and salvage charges adjusted determined according to the contract of carriage and/or governing law and practice incurred in connection with the avoidance of loss of any cause except those excluded in certain clauses. Turning to car insurance, you have this very long clause, but again confirms that a car insurance will respond to contribution to general average and salvage charges. When it comes to subsea equipment, ROVs and similar, these clauses are often insurer specific. This is one example, covers GA, but there is a kind of, in my opinion, strange limitation of 25% of GA charges as adjusted in this example. Turning now to the Nordic plan. The Nordic plan can be the basis for hull and machinery, car and subsea equipment policies. And it has some provisions which applies to all kinds of insurances in part 1 or chapters 1 to 9. And that part includes some clauses related to general average. Hull and machinery insurance would normally be subject to Part 1 and Chapters 10 to 13. Car insurance, Part 1, and could be relevant parts of Chapter 18, and it could be special conditions. Subsea equipment, normally as per this Part 1, and also some special more insurer-specific conditions. And here is an extract of the GIA provisions in the Nordic Plan Part 1. The insurer is liable for any general average contribution apportioned on the interest insured. The hull insurer is also liable for general average contribution apportioned on freight and charter party hire, provided that the assured is also the owner of this interest. And clause 410, if the object insured has been damaged or lost as a result of a general average act, the assured has the right to claim compensation for such damage or loss in accordance with the rules relating to particular average, without first enforcing the right of contribution from other parties. So, in practice, this means that insurers would cover the proportion of GIA apportioned on the interest insured, with a possible addition on the freight and CP higher proportion from hull insurers, as was mentioned on the previous slide. Sacrificial damage to the object insured can be recovered in full in first instance. Insurers will then be subrogated to the assured's claim in general average. The assured has a duty to maintain and safeguard such claim. And actually the commentary to the plan's clause 516 states that if the general average claim exceeds the general average absorption clause and no steps are taken by the assured to secure right of recourse, the assured will usually be liable for any loss incurred by the insurer due to such failure. The other kind of insurance we have mentioned is cargo, and cargo is actually not a feature of the Nordic Plan, but just for the completion I'm showing you here. Clause 40 of the Norwegian cargo clauses, also dealing with general average. So, going back to the common safety and common benefit principles. Firstly, offshore construction and support vessels often have property on board of different ownership, so that the general average might arise. And that can also be the case if property has the same ownership but is separately insured. That is mentioned, for instance, in the Nordic Plan Clause 4.9. The common safety cost is not problematic to identify. I mean, it's cost of a tug to save a vessel and other property on board. The common benefit may be a little bit more difficult, because the York Antwerp rules talks about safe prosecution of the voyage, and these vessels are not always on a clearly defined voyage. So, if turning to the literature, we then have in Loans and Rudolph the following paragraph. In place of an identifiable voyage from one place to another, there will often be a contract to carry out a specific task or set of tasks in a given location. In this case, it is suggested that allowances under Rule 11, which deals with common benefit costs, can reasonably be made with a view to repairs necessary for the safe prosecution of contractual works. So, here we are replacing voyage with contractual works. And for some specialist vessels on long-term charter parties, that defining contractual works can also be difficult. I've seen a few cases where this has been discussed by average adjusters, and from what I've seen, the charter period seems to have less relevance to what is defined as the contractual works, but the actual operation of the vessel engaged, the vessel was engaged in at the time of the occurrence seems to be more determining. So if the construction vessel is on a 4-year time charter, you would more look into what are the tasks she is doing at the time of the occurrence, and what is needed to get back to that. So what can we learn from this? These are the takeaways we have put up. General average is there as a matter of law, whether or not it is mentioned in charter parties. Including a general average clause in the charter party is an advantage to secure certainty as to how general average should be dealt with. If contracting out of general average, parties should consider securing special insurance cover for what cannot be recovered from other parties, if that is possible. I believe there might be products in the market where you can buy a GA cover, but it will come at a cost. To avoid full GA procedures for smaller GA situations is of course important to ensure that the vessels involved have a reasonable general average absorption limit in their hull machinery policies. Thank you.
Both for highlighting the issues relating to GA in the offshore industry. I particularly liked your reference, Michiel, to GA on land. Going to bring that concept in? Is that your new project?
Well, certainly good for average adjusters that they can actually also look into tire values, etc.
Yeah,
So,
exactly. Just before I open questions to the floor, I do have a quick question, if I may. If charterers agree to include a GA clause in the charter party, but don't include an exception in the knock-for-knock, what happens then?
well, this is the matter where you then would have to look at the knock-for-knock clause, and that starts with notwithstanding anything else contained in the charter party. And basically that overrules the general average clause again. So you first put it in, but because of this wording, it overrules it. That's why it is relevant to put that exception in the knock-for-knock clause.
Okay, thank you. Do we have any questions from the floor? Can I give you the mic? Is this working?
Hello, thank you. I have a few questions actually. First of all, with Alf's reference to securing the right of recourse for GA sacrifice, could you please clarify it, how it should be done? Is it just simply getting the right security, or because I was a bit confused about how my ship owner may fail in that recourse action? Yeah. Question one. More coming.
Yeah, I mean, it's I guess it's slightly different between the English and the Norwegian system. So I'll start with the Norwegian system, which I know the best, where you have an obligation to secure the rights in general average, and if not, you will run the risk of having to compensate insurers for what they lost. So you need to go out and get security, basically. Under the English system, I wouldn't put my head on the block, and yeah, I think it's could be arguably similar, but I guess it could be also argued in another direction. There are a lot of English average adjusters in the room who could probably comment more on that.
Thank you. I didn't understand what the reference exactly meant. Now I do. Thank you. So, if I may say so, Michiel, if you didn't have that accident, you wouldn't have become aware of the fact that GA wasn't specifically mentioned in the time charter parties, and there may be other owners who are not aware of that fact and may have a casualty. And what happens if an LOF is signed?
Well, to start off with the last one, if it's only an LOF, then you will have salvage only. And the advantage with salvage is that the salvor goes separately to hull and to cargo. So they will say, look, you have to pay so much. And hull, the ship has to pay so much. So I think that is the system that exists, and that follows actually even if this has all been excluded, that salvage from this from the contract. So that will not be a problem. No, but if This was also something that I raised with the BIMCO. I said, well, surely we are not the first ones. The wind time is there since 2013, so it's already there since 10 years. But they had never heard anything about the fact that the GA clause was not there. So apparently we were the first ones, or the first one, or maybe the second one, that actually noticed that this clause had disappeared. Correct?
Michiel, when they were drafting the 2017 supply time, someone must have specifically taken out the GA clause that was in the 2005, or not?
Well, the BIMCO actually stated that they were following the wind time 2013, and it was taken out there. So they thought this must be right. So this is why we we just copy this. And yeah, it's no, it's not like that.
So sign an LOF if you have to be told as a ship owner.
You should also pay more than usually. No cell force in the room now.
Joking aside, not to get in more trouble in that subject matter. Last question, please. In your case, did you have difficulty collecting security? And because GA was not mentioned in your time charter, was there anything specific to that collection? Because you mentioned that Tasmanian law was to be followed. Thank you. Last question. That was it.
Well, that's a good question. I also know the answer. I only lost some sleep overnight. I then discussed with our chartering department, and we managed to find a solution. What happened here is basically we were in Perth. We had carried out temporary repairs. The class agreed that she could then continue the voyage. AMSA came and said on the last day, said, no, you're not going to continue your voyage to Tasmania. You go to dry dock in Singapore. The cargo that was on board the ship was not very heavy. This was equipment that was taken from these research stations. Very interesting, actually. They had this big ice that they had collected from a certain depth. So then you can look at how the world looked like a million years ago. So this was valuable, but it was actually only water, wasn't it? If it melts. So, so what is the what is the value of that? Now, they did not want to carry this ice all the way to Singapore, so they agreed in the end that they would pay for the discharge of the cargo in Perth and put it forward to destination, which for us was good news, because then that was not in GA, if it would have been anyway, but the GA stayed within the absorption clause. So it never really materialized that we had to collect GA security from cargo interest. Luckily.
Thank you, Michiel. Do we have any other questions from the audience? Mr. Jones.
Following on from Melis, I've also got a couple of questions, actually, if I may. Michiel, to start with, without wanting to sound cynical, how many people do you think will actually read the BIMCO advice and potentially understand the ramifications?
Well, I think the TikTok generation will not read it. But I do hope that professionals will read it. It doesn't happen very often that there's a separate advisory note with the clause. So if you go to the BIMCO website, you see the supply time there, and then it says specifically, read the advisory note. But to open it up, then you have a page and a half you have to read. Yeah. To be honest, I think that this is also the purpose why we are explaining this all here, is to pay attention to it, so that people do know. And certainly when there are brokers, they need to advise their clients to pay attention to this. The adjusting world would also be very pleased that it will be read, because how are you going to get a general average adjustments as per Tasmanian law? It's silly. Also, the general average clause, which I didn't mention, also specifically exclude hire not to contribute to GA, which is also a relevant item that is in the GA clause. There are not many adjusters here, I would think, that has actually adjusted higher as per the general average. I hope there's many here, but this is also something that goes back to the 101 damnations, isn't it?
Yeah.
So, yeah, this is an inside adjuster's note, but joke, but okay. So this is the, so when you didn't laugh, of course, that is totally normal. But yeah, so this is the answer to the question, yeah?
Yeah,
Okay.
lovely, thanks. And Inge, I must admit I'm not a great expert on the world car conditions, but it's surprising. I think it said general average to be adjusted according to 1990 as amended. Well, obviously there wasn't a 1990 rules, it was 74 as amended 90.
Yeah.
But when you see the words as amended, you do wonder, following on from the Star Antares, whereas that actually now means 2016.
Yeah.
So
You
I
may
think
wonder.
that wording, if there's any world car people, that wording should be tightened up. Super, thank you very much.
Okay, good.
So the question is, if a GA clause is excluded from the Charter, and this results in a much more difficult and contentious claim for GA, wouldn't it make sense to include the GA clause in the Charter as a default?
That would make a hell of a lot of sense. But this is, of course, up to BIMCO to make new clauses again. The good reason is that we discovered this, that we raised it with BIMCO, and that any future contracts will again include the GA clause. But the BIMCO cannot take the supply time 2017 and then include that as a default clause. It's not in there. So that's why parties need to incorporate it in the charter party. But yeah, it's a difficult job, because I'm lucky that I have some adjusting background, but there's a lot of ship owners who cannot even explain, of course, what general average is to their charters when they start to negotiate it. So I fear that 75% of the ship owners have no idea what this is all about when they read the advisory opinion. Hence, adjusters, go and give a call to your good clients and explain it. Hopefully, you understand it after this presentation.
Do we have any other questions from the floor? Perhaps one last question I have just before we finish, bang on time. So if you exclude the GA in the contract, is that going to mean adjusters don't have so much business?
Who said yeah? You should always end with a good news show, isn't it? So the answer is, of course, no. There is still some expenditure, some loss. Do the insurers know what it is? No, there is adjusters. There are adjusters that need to decide what is general average, what is particular average. As Alf pointed out, section 64 of the Marine Insurance Act. General average and particular average are two separate things. So if you've even decided to exclude it between the parties, that general average will not be apportioned amongst the parties, there is still general average. And also, when you look at P&I also would like to see what, if a division has to be made, what is the cargo side and what is the hull side. Every hull and machinery underwriter would like to know, dear ship owner, fine that you spent 100,000. I will pick up that bill. No, a hull underwriter would like to know how much of that 100,000, dear ship owner, is actually falling on the ship. How much would have fallen on the cargo? Most ship owners cannot decide that. That's why they need an adjuster. So the only difference would be that the collection of general average security is not necessary anymore, but the actual adjusting work, which to me would be the most exciting work, of course, in an adjuster, that is still there. So I would say positive news, yes.
Good.
They still
Okay.
have a job.
Well, I think everyone will agree that was a most interesting presentation, quite a lot of questions as well. Hopefully you'll all be able to join us for a quick light lunch. It's upstairs today rather than where we had coffee.